I had occasion to, my lord, I went through your lordship's judgment. My lord, my humble attempt is to bring to your lordship's notice two manifest errors. No, no, my lord, my contention is the primarily on two bases. No, my lord, no, no, no. This is a different case. It's a different man. No, my lord. Now no, my lord. No, in all humility, I will say that why that view is not correct. No, no, my lord. No, no, my lord. Say, your lordship here may disagree with me. No, 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 what I say, my lord. No, but I am only for the proposition of law. Uh, No, no, my lord. No, my lord. I'm only on a proposal. I'm not touching your lordship judgment. Fine. Not that I'm agreeing with your lordship, but since your lordship insists that, I'm not touching on that. This is a, my lord, parties are different. Cause of action is different. Controversy is different. List is different. For a virgin sand, on a absolutely virgin oil. Just give the MSMEs. My lord, my contention is there is no requirement at all of my ever being the requirement at all for me to make an application. I cannot apply. From day one, I argue the same before Justice Bharat Trivedi. I argue the same before the Bombay High Court. I've been doing this exercise innumerable times. From day one, I'm saying that a borrower cannot apply at all once there is a default in the account. And no, no, one second. Let me complete it, my lord. And the moment, yes, yes, yes. No, my lord, yes, I listen. Yeah, yes, yes. No, no, no. My contention first. No, no. First, my contention is not recorded. Then you can say your lordship record my contention. No, 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 no. My lord, finding is where, in all humility, when your lordship record that this is the contention of so and so, I reject it for X, Y, Z reasons. So my contention has not been recorded ever. No, 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 no. My lord, my contention. See, my lord, my contention. No, 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 my lord. No, 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 no. I beg to I beg to disagree, my lord. I beg to disagree. No, beg to disagree. My lord, beg to disagree. My lord, the first principle. My lord, no, 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 my lord. No, no, I'm on basic jurisprudence. If I'm wrong, your lordship, I have to say I'm wrong. No, my lord, I'm giving a reason. My, no, my lord. No, my lord, your lordships may hear and disagree. No, no, this case has not been here. My lord, parties are different. Cause of action is different. No, my lord, no, one second, my lord. In our system, in a constitutional democracy, courts, yes. No, my lord, one second principle is what is a precedent is, whether it is by your lordship's judgment or somebody's judgment, what is a precedent is what is correct. No, no, one second. Nobody can say that I will follow what is wrong. What is manifestly wrong? No, no, my lord, your lordship's judgment is not a my lord, precedent at all. One thing, in all humility, let me say what is a precedent. One second, the concepts. No, no, once, don't interrupt me. What the concepts? No, no, no. The concept, the concept is
Your Lordship, in this case, where all the banks have issued only symbolic position, insurance stake is granted only in my case, where I am not even a necessary party. And I've been trying from three postings, trying to explain, convince the court that because I'm a non-finance banking company, it doesn't stand against me.
Who said you know that is a matter? You file a counterfeit, we'll argue it. Yes, yes, that is why I'm arguing. When I argue, you can reply to it. See, I am only asking one. Let us one first principles. What is a precedent? What is a residuicata? No, 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 no. I'm arguing my case, not lecture. No. I'm arguing. One second, my lord. If your lordship may disagree with me in the strongest ways. No. Your lordship may disagree with the reasons. Reason record my contention. Disagree. Impose cost. I have no quarrel. I am no. All with all humility, I say, I'm not asking for any order in my favor. The court has, my lord, the court has with its jurisdiction to err. To err, the court is free to err within jurisdiction. But that error, the court is. Let me 1 second. No. This court has no error to jurisdiction to error on law. This court has the jurisdiction to err on facts. That is fundamental. It's fundamental principle that is called res judicata. Res judicata pro veritate accipitur. A judicial decision, right or wrong, is final, binding, authoritative. The court has no power to err on law, and that is the first principle that res judicata facit ex albo nigrum, ex nigro album, ex recto garbum, ex garbo rectum. A judicial decision can make on facts what was white black, what was black white, what was straight crook, what was crook straight. So a court can say 1 plus 1 is 0. Court can say black is white. I will accept it. I am bound to, if a lordship has said, committed and said 1 plus 1 is, my convention is 1 plus 1 is 2. Your lordship hold that 1 plus 1 is 0. It is manifestly wrong. I will not come here. Because your lordship is free to err. Free to err within your jurisdiction on facts. Your lordship is the master of the facts. Your lordship is not the master of the law. Your lordship is a servant of law. Servant of law. If your lordship is wrong, your lordship is duty bound to correct it. That is why Antulays says, if where your lordship is wrong, it is corrected. So therefore, it is not a lecture class, but we need to understand basic jurisprudence. What is res judicata? What is precedent? What is election of forum? What is election of remedies? These are fundamental things. What is a substantive remedy? What is a constitutive remedy? What is cumulative remedy? What is additional remedy? All these basic things. The mistakes which have been committed is the word. First, I'm so sorry to say with all humility, the mistakes are on force of fundamental. Nobody knows what is the meaning of a remedy. Nobody knows what is the difference between a remedy and a forum. The remedy and a forum. And I have written an article why very eminent lawyers, judges all say that mistake forum for a remedy. There is a historical reason. There's a historical reason. Therefore, we need to. This is not a lecture class, but we need to discuss law. And why I stand on a firm founding, because I spent some time of my life in the early years in studying law. When judges discouraged me from my lord arguing law. Justice jurisprudence come from Rome. All our jurisprudence is based on out of the four sources of our law. The foremost law, the first principal source is Roman law, Latin. It is in Latin. We can't help it. Res judicata pro veritate accipitur. Yes, that is res judicata, section 11. I am only on section 11. Res judicata, because these enactments are enacted by people who don't have the basic knowledge of law. This Surface Act is fundamentally wrong. Your lordship dismissed my case 10 times. I'm totally unconcerned. I'll come with the next case because new cause of action has arisen. There is no termination of lease. Look at the Surface Act. There is no termination of lease. In one case, 87 times he fought. I have produced the judgments. Your lordships may kindly go through those judgments. Yes, in the Justice Sham Suman. Justice Shyam Suman, after dismissing my case, said, paragraph 18 said, everything is reopened. You have this Justice Shyam Suman judgment. My lord, see, I am a student of law. If somebody says I am wrong, I am willing to accept it. Nobody has told me in the Dumbara, for these reasons you are wrong. Something else he said. The question is, when I talk about, my lord, the bar, when if a suit is instituted, a surface action cannot be maintained. That is not my invention. That is fundamental principle of law. That is what the legislature has said. Yes. I take your lordship to Justice Suman. I am taking paragraph 18. And because I stand, my lord, unconcerned of the personal injury to me for what is right. That is why I am here. Here, my lord, yes. Paragraph 18 in my petition. For the reasons stated above, we are of the view that there is no scope for this court to entertain the writ petition. The writ petition therefore stands dismissed. Interim orders passed earlier also stand vacated. Liberty is, however, granted to the petitioner to avail appropriate legal remedy in accordance with law and in terms of the leave granted by the judgment dated 11 January 2024. That is in Naveen Chandra, as well as the decision in Pronix. So, to similarly situated MSME units, if so advised. So, my lord, your lordship's dismissing is of no consequence. I will not go to an appeal. Because when I go to an appeal, when there is a adjudication on facts, your lordships have said, yes, the number of 1 plus 1 is not 2, 1 plus 1 is 0. I will accept it. I am bound to accept it. Because that is the reason. The doctrine of res judicata, this is not mine. Roman lawyer said, res judicata pro veritate accipitur ulpian. Ulpian said res judicata pro veritate accipitur. What is the reason? Interesto republico ut sit finit litium. It is in the interest of the republic there shall be finality of litigation. And again Ulpian said, nemo debet bis vexari pro uno et idem cosa. Nemo debet bis vexari pro uno et idem cosa. No man shall be vexed on the same question more than once. Therefore, that is the doctrine of equity. My lord, why? You must read the history. Why Bentham fought for amalgamation of the two streams of justice. Two streams of justice. See, my lord, all these mistakes have come because of, sometimes we forget the fundamental principles. What is action law? There are two streams of justice. One is in common law code, what we file a suit we file is called action. And the citizen agreed by the judgments of the normal common law code went to the court of equity. Then equitable relief, the concept of equitable relief, that is equitable remedies, injunction, specific performance. So ever so many equitable remedies, set of counterclaim, all this, so not counterclaim, set of counterclaim, all these equitable remedies evolved. And later, my lord, a demand came that equitable remedies and common law remedies, a man who has approached the court of common law court should be able to seek simultaneously equitable remedies. Therefore, in 1852, Judicature was amended, Act was amended and said, yes, in a court of common law court, equitable remedy can be sought, and in a court of equity, common law remedies can be sought. So then still these two streams existed. Then another principle came. If you have invoked the common law remedy, then you cannot invoke equitable remedy. You have to elect between that. And why there's a common mistake. See, very eminent lawyers, most of our judges say, remedy, you have an alternative remedy. The judge actually means an alternative forum. You can go to the DRT, alternative forum. But why everybody says the alternative remedy instead of alternative forum? The reason is historically, when somebody had gone to the court of equity, then it is an equitable remedy. So court of equity and remedy and forum sometimes use, my lord, interchangeably. Its meaning is distinct, but used interchangeably. And therefore, that is how this misunderstanding came, misconception came. So the remedies are common law remedies and equitable remedies and declaratory remedies, which is called sui generis. Now, common law courts and court of equity all amalgamated into one in our system in 1859 when the CPC was enacted. That is why I said all parties, all causes, all controversies before one forum, and his decision final and binding, authoritative, final and binding, right or wrong. So my lord, our jurisprudence is that the equitable concept, that you have to elect between the forum, that became an equitable concept. Roman law, there was no need, because in Roman law there was only one court. There was no two different courts. So the concept that you have to elect the forum, if you have gone to the equity court, then you have to come to the common law court. If you have come to the common law court, you cannot go to the court of equity. The election of forum and election of remedies. So what is it? See, the all discussion is about you. My petition, my prayer is, let the bank have all remedies, but one forum. I am not. So the forum remedies are, see, my lord, now specific performance. If I am finding it difficult to find out, the concept is a party can have all remedies unless there is an inconsistency. If there is an inconsistency, then the party has to elect. And there are not much of a discussion, any judgments in this country on this subject. Then the inconsistency, probable inconsistency, is specific performance and damages. As not a suit for specific performance. Specific performance is an equitable remedy. It never existed in the common law. Common law principle is restitutio integro. Or where it is not possible, damages. Specific performance is an equitable remedy which has been evolved in the court of equity. So specific performance and damages, both cannot, they are considered to be inconsistent remedies. Again, anybody can help me. If there are inconsistent remedies, there are not literature, much of a literature available is available here. So, my lord, therefore, what I asked the court to, my lord, consider what is expressly stated by the parliament. The common law concept that the common law concept, and we inherited the common law from the English. So what is codified in CPC, or what is our jurisprudence is that a litigant can have all remedies, but there can be only one forum. And that principle came to be incorporated by our parliament in two amendments. Give the surface here. Surface here. Can you? Anybody has got surface here? Okay. Yeah, I got it. Yes. Yes. I am not asking for any, no judgment is required. I am asking for the plain meaning. If something is contrary to, Transcore was completely contrary to that, and I explained why Transcore is per ingurium. It has to be recorded. I am not answering that there should be a judgment in favor. My contention is, I take your lordship to first proviso to section 19. This is a battle which I cannot afford. I cannot give up. I have to have, in public interest, I have to have it, and the interest of my client, I have to fight it. That there's no choice. I left to myself, I would have never wanted to fight this cause, but I have no choice. Section 19, proviso to section 19. What is a precedent is what is right. If something is manifestly wrong, an error is never a precedent, and never will bind nobody. And Krishna has said, even the author. If your lordship, if I were to quote Krishna's own words, it will not bind even the author. If your lordship has written something wrong, here all mistakes came from the judgment of the Supreme Court in Transcore. I am taking your lordship to para 1. Provided that the bank or financial institution may, with the permission of the debt recovery tribunal, on an application made by it, withdraw the application, whether made before or after the enforcement of the security interest and recovery of bank debts laws amendment act of 2004, for the purpose of taking action under the securitization etc act of 2002, if no such action had been taken earlier under the act. So this enactment only says, if you had taken an action and a notice under section 13(2) is an action, then you don't have to withdraw the OA. In all cases, before invoking SURFACE, you have to invoke the OA. So we have to withdraw the OA. And section 13(10), at page 31, section 13(10), where the debts, where the dues of the secured creditor are not fully satisfied with the sale proceeds of the secured assets, the secured creditor may file an application in the form and manner as may be prescribed by the debt recovery tribunal having jurisdiction or a competent court, as the case may be, for recovery of the balance amount from the borrower. So therefore, all this, the legislative intention is that the doctrine of nemo debet vis vexati pro uno et idem causa, no man shall be vexed at the same time or by more than one proceedings. Nemo debet bis vexati pro uno et idem causa, and that is the section 10 of the CPC. Yes, I'll say that. The section 10 of the CPC, section 10 of the CPC. These are fundamentals. So, this principle cannot change. If our Supreme Court has made a mistake, an error, it is my duty as a lawyer to point out to the court. And this error cannot, say, suppose I am arguing this matter before the Supreme Court. I can say, yes, the court can say, we refer to a larger bench. When I am, suppose I am arguing this matter before a municip, what the municip will do? Can he leave his chair and say, I am helpless? He has to decide. He has to decide whether the statute will prevail, or whether the judgment is in consonance with the statute or is contrary to statute. If a judgment is in contrary to the statute, then that judgment is per incurium and sub silentio. If the relevant provisions has not been discussed, it is sub silentio. Therefore, the only question that was in Transcore, I take your lordship to Transcore. The only question which was before the Supreme Court in Transcore was, I take your lordship to Transcore. This is, if somebody gives me a valid reason, I will stop. I will never argue it. Because nobody has been able to give a rational reason, say why I am wrong. As a lawyer, I will never accept a good reason, because that is then we need the vitality of the bar. Bar becoming servantary is not good for the institution of judiciary. Bar, it is not in the public interest. Bar has to be, my lord, bar has to be fearless, conscientious, stand for what is right, and fearlessly say what if something is wrong is wrong. I am here, this judgment is completely wrong. It has gone on a completely misconception of things. I read only 2 paragraphs or 3 paragraphs, just 5 minutes only. This may I take your lordship to page 136. In March 2099, OA number 354 of 1990 was filed by the Indian Overseas Bank before the DRT Chennai for the recovery of dues from Messrs. Transcore, the appellants herein. The claim was disputed. An interlocutory application was filed by the bank in the said OA to bring the properties to sale. That IA is pending even today. On 6/1/2003, a notice under section 13(2) of the NBA Act was issued. It should have been used surfaced Act. So much of confusion. On 11/11/2004, the following provisions were introduced in section 19(1) of the DRT Act by amending Act of 30 of 2004, provided that the bank or financial institution may, with the permission of the debt recovery tribunal, on an application made by it, withdraw the application, whether made before or after the enforcement of the security interest and recovery debts laws amendment act of 2004, for the purpose of taking action under the securitization etc act of 2002, if no action had been taken earlier, if no such action had been taken earlier under the act, provided that any application made under this first proviso for seeking permission from the DRT to withdraw the application made under subsection 1 shall be dealt with by it as expeditiously as possible and disposed of within 30 days from the date of such application. My lord, this proviso was incorporated because the Punjab and Haryana High Court in Kalyani said two simultaneous actions cannot be initiated and continued. The bank has to elect between the two forum. And then the parliament wanted to protect the steps which has already surface the actions which has already been taken, and therefore said those surface actions, that is 13(2) notice etc issued prior to 11/11/2004 shall be allowed to continue. So therefore this proviso, whether action taken or not, has relevance only up to actions taken on or before 11/11/2004. Any steps taken after 2004, you cannot have two proceedings. And then next paragraph, it is all the more clear. Paragraph 5. On 8/1/2005, the said bank issued a possession notice under the Surface Act, under section 13 of the NB Act, read with rule 8 of the Security Interest Enforcement Rules, etc., stating that by notice dated 6/1/2003, the appellant herein, that is Messrs. Transcore, was called upon to repay an amount of rupees 4.5 crores, together with interest within 60 days. That appellant had failed to repay the amount. That a notice was also given to the guarantor. That the appellant had taken possession of the immoral properties mentioned scheduled to the notice, and that the appellant and the guarantor were directed not to deal with those immoral properties. By the said possession notice, the public in general were also told not to deal with the properties mentioned in the notice, as they were subject to the charge of the bank for the aforesaid amount with interest and cost. The immoral properties were put to auction. However, pending civil appeal, confirmation of the auction sale had been stayed. Now, as far as Transcore, the appellant herein is concerned, the argument is that the respondent bank could not have invoked the Surface Act under the proviso to under the Surface Act under the above proviso to section 19(1) of the DRT Act without prior permission of the DR tribunal before whom OA number etc. was pending. The contention of the appellant is that prior to the insertion of the proviso on 11/11/2004, the bank had issued a show cause notice under section 13(2) of the Surface Act. That notice dated 6/1/2003 was merely a show cause notice, and such a notice did not constitute an action taken in terms of the proviso to the said section 19(1) of the DRT Act. The only issue was the notice was an action taken or not. The contention was it is not an action taken or not, therefore simultaneous action can be continued. But the notice issued under section 13(2) was an action taken, and therefore it is protected because of the amendment which protect all actions taken prior to 11/11/2004. So therefore, that was the only issue. Next, briefly, the first proviso states that bank or financial institution may, with the permission of the debt recovery tribunal, on an application made by it, withdraw the OA made before or after the amending act 30 of 2004 for the purpose of taking action under the NPA Act, that is Surface Act. If no such action had been taken earlier under the Act, that was the only issue. What is the meaning of the word action taken? The contention of the borrower is that notice given by the bank on 6/1/2003 was merely a show cause notice, and such a notice did not constitute action in terms of the said proviso. Consequently, according to the appellant, the bank was duty bound and obliged to make an application to the DRT seeking withdrawal of the OA. The appellant contends that in the present case, the proviso has not been complied with by the bank, and consequently, the possession notice issued by the authorized officer of the bank under section 13(4), etc., was illegal and bad in law and liable to be set aside, as the bank could not have invoked the Surface Act without prior permission of the DRT under the proviso to section 19(1) of the DRT Act. So that was the question. The question in Transcore was whether the 13(2) notice was an action taken or not. And I would submit, my lord, it is an action taken. And therefore, since in view of the amendment which protects action taken till 11/11/2004, in the Indian Overseas Bank could have in Transcore pursued both action. That was the case. That case, my lord, the Supreme Court went on to discuss the issues which were not before the court. Now, my lord, I take your lordship to page 37, page 149, para 37. 3 points arise for determination in these cases. They are follows. Whether the banks and financial institutions having elected to seek their remedy in terms of the DRT Act 1993 can still invoke the Surface Act for realizing the secured asset without withdrawing or abandoning the OA filed before the DRT under the DRT Act. That question did not fall for consideration. The Parliament said no. If the Parliament said no, who is the court to say yes? No lawyer asked that. When a Parliament enacts a law, we all are symbolically present. It is with our consent a law is enacted. A record of a Parliament binds all of us. Record of a court binds only the parties. And look at the injustice. I was not a party to that. I couldn't have offered my contentions. I couldn't have said this has meant a different interpretation. So judgment of a court is not the law of the land. Somebody has to say that. The Supreme Courts of the judgments are not the law of the land. Supreme Court judgments are only binding the parties. It is not the law of the judgment. That is the res judicata. What is the res judicata? Right or wrong, a judgment is binding. Supreme Court judgment is not binding. That is what happened in many cases. That is fundamentally wrong. These are basic jurisprudence. You cannot shut our eyes to that. Judgment of the Supreme Court is a precedent. As a precedent is binding. A precedent is, what is a precedent? A principle. A principle which has repeatedly and repeatedly reaffirmed. What is a principle? The principle is binding. And if something is contrary to the statute, it is not a principle. It is simple error. And that is why, my lord, we have a duty. See, errare est humanum. To err is human. To persist in error is diabolic. This is diabolic. And, my lord, therefore, this issue, this is, see, bank can have all proceedings against me. I cannot have multiple proceedings. They cannot. This is the equity means what? The judgment says in the Transcore, it says it is only for the creditors, banks and financial institutions. This country doesn't exist for bank and financial institutions alone. This country exists for animate human beings, citizens. Banks and financial institutions exist for the purpose of we the people. We are not subservient to their interest. So therefore, my lord, then how the mistakes came? I take your lordships to, yes, the judgment. Paragraph, paragraph, yes. If it is somebody should say I'm wrong, I'm happy. I'll correct my mistake if I'm wrong. Nobody has been able to offer a logical, intelligent reason. If I'm wrong, tell me why I'm wrong. I may I take your lordship to paragraph 53. May I take your lordship? Yes. Mr. Solicitor Rabji Lena, senior counsel appearing for the Indian Bank, submitted that the doctrine election does not apply to curative relief. What is a curative relief? What is a cumulative relief? What is there are say cumulative relief. Cumulative relief for an MSME, the protection under the notification dated 29/5/2015 is a cumulative relief. Other relief which I seek is under the contract. Then he submitted that a creditor is entitled to choose one or more of the cumulative remedies open to him, unless procured by statutory provisions of the doctrine of election. I am saying in every petition, my declaration is that declare that the creditor has all remedies. You call it substantive, you call it adjectival, you call it constitutive, you call it adjectival, cumulative, curative, whatever name you give, common law, equitable, declaratory, all. Let the bank and financial institutions have all remedies, but there can be only one forum. There can be only one forum. There is no. I'm not asking them to elect remedies. I'm not saying that there is any inconsistency. I'm saying I am arguing more than in favor of the bank than Solicitor Abdi did. Let the banker have all remedies. Then next, he submitted that. He submitted that the creditor is entitled to choose one or more of the cumulative remedies open to him, unless procured by statutory provisions or doctrine of election. That in the absence of any bar, it is open to the creditor to choose one or more of the cumulative remedies. Learner Council submitted that under the scheme of the Surface Act, a bank or financial institution is under a disability, and there is no disability to take recourse to Section 13 of the Surface Act, even after it is invokes Section 19 of the RDD Act. He submitted the object of both the section is to recover dues, and that there is no inconsistency or inherent implied between the two remedies. That is two actions, two forum. Remedy and action are different. The doctrine of election applies in case of inconsistent remedies. The doctrine of I'm not saying that there is inconsistency. The bank can have all remedies. He submitted that in the present case the two remedies are not inconsistent to each other. He submitted that the judgment of this court in AP State Financial Corporation has no application because in that case the court has held that the State Financial Corporation Act has especially provided the doctrine of election. The same has done here. Financial Corporation Act has said you cannot have two forums. You have to elect between the two. Then here in this under the Surface Act, the bank has required to elect between either the action under the Surface Act or under the Recovery Debts and Bankruptcy Act, not ni bis in idem, not the twice, no two things at the same time, ni bis in idem. The Nana Council submitted that the doctrine of election is a doctrine evolved by the Court of Equity. Complete agreement. It is based on the principle that a man shall not be allowed to approbate and reprobate. Yes. Now I take your lordship to that Snell on Equity book. That is the book. I'm giving a copy. No, madam. Yes. No, madam. Let me hand it. I'm nowhere. Yes. Here is the copy. Sending copy to the
graphic documents are produced where RBI has specifically said that
election.
under MSME cannot be used against NBFC banks.
No, no, I'll pass on the book.
Yes.
I'll.
And the right to information also they have clearly said. That is my second document.
No, madam, I am not listening. I am not listening anything what you said. I am busy with the. No, I didn't hear what you say. No,
You may be vacated.
no, what you said you are not applicable.
Yes. And
I will argue that.
you are not arguing, sir.
No, my dear friend, you reply when I complete my argument. You cannot interrupt me.
It's not about my case.
I am talking
504 is about 5 to from 3 postings have been.
504. You are against me, appearing against me.
Yes.
I am on my legs. Okay. This is an academic thing. There is nothing like that. You must learn. I must learn. This academic. There is nothing beyond that. If the courts commit mistake, we have to point out the court. Pardon, my lord? I am just passing on the book to your lordship so that I can read from my. No, I am passing the book to your lordship. Yes. Snell on equity, yes. I'll read it 2-3 sentences more, then I'll come to Snell on equity. Yes. Yes. No, it will take time, my lord. It is a pure academic issue. Let me at least read up to this. 1 hour, certainly, yes. It is based on the, yes. My lord, your lordship doesn't have that judgment. Yes. It is based on the principle that a man shall not be allowed to approbate and reprobate. If a person has chosen a particular remedy and he has intentionally relinquished another remedy, he is debarred by the doctrine of election to pursue the remedy he has intentionally given up. Not forum. Learned counsel submitted that a creditor is not precluded by the doctrine of election if he makes a choice of one or more cumulative remedies available to them. I am asking them, you have all remedies. The adoption of remedies under section 19 of the DRT Act and under section 13(4) of the Surface Act are not inconsistent with each other. It is about forum, not remedy. Which one? No, my lord, what I am saying that, yes. No, my lord, why the hostility? It's an academic exercise. Yes. No, yes. Yes. My lord, the other day I read out Article 226. I am entitled to, the Constitution protects me to approach the High Court for enforcement of fundamental and legal rights. It speaks of 5 writs and writs in the nature of certiorari, mandamus, prohibition, others I am not concerned. A certiorari is a matter of right. First principle. Most people have a misconception of it. Certiorari is a matter of right. Certiorari will lie if a proceedings of a subordinate tribunal is vitiated by errors apparent on the face of record. The tribunal here is the author. Yes. Now I am on the maintainability. Yes. All surface, I am on the maintainability. I am coming there. I am maintainability. All proceedings under the Surface Act, Padamelo? Yes, right from classification of my account of NBA. What I am challenging is that you did not extend me the benefit of the notification. So I am seeking a certiorarified mandamus. But that's what Madras law is used. Certiorarified. All proceedings. SURFACE Acts, IBC, or Recovery Debts and Bankruptcy Act, Negotiable Instruments Act, everything. Yes. Yes, yes. I didn't have it immediately. Can I have it? I will look at it. Yes. Ah. Ah. No, this is a binding. No, this is some inquiry. The framework issued under the circular, etc., is not applicable to NBFCs. That is wrong. No, no. Yes, yes. No, sir. My lord, Reserve Bank said administrative order. It is not a law of the land. Law of the land is this. No notification. They are coming to that. So one second. No, no. Let me. I am on my legs. I am on my legs. Since he has said the notification says before a non-account of a micro, small and medium enterprise turns into a non-performing asset, banks or creditors are required to identify incipient stress. Whoever is a creditor, NBFC is a creditor. Creditors are required to identify incipient stress. This argument was raised in the case of Naveen Chandra. The terminology used is creditors. So if they are not a creditor, fine. And the term creditor is defined in the SURFACE Act. And it's a terminology of general application. So therefore, and this petition, there are not only one bank, other banks are there. I have followed CPC. I have followed CPC. Now somebody would say, now CPC, order 1, rule 1, CPC. Yes. I'm answering that only. I'm answering that. No, I'm answering that only. I don't believe the right to approach Article 226 as a matter of charity. I believe it's a matter of right, as constitutional right. Then I have sought a written the nature of certiorarified mandamus and a written the nature of prohibition and declaratory reliefs also, holding that on the premise that the entire proceedings initiated by the various banks and financial institutions, including my friend's client, are without jurisdiction. Are without jurisdiction. A. B. In violation of the principles of natural justice. C. In violation of the express statutory provision. In violation of the without jurisdiction, because the notification dated 29/5/2015 mandate that no recovery action can be initiated or continued except in the manner permitted by the committee to be constituted in terms of the notification. So the paragraph, I take your lordship to paragraph 70, page 73, para 543. Once the first two options at A and B above are not feasible, due recovery process may be resorted to. The committee may decide the best recovery process to be followed among the various legal and other recovery options available, with a view to optimizing the efforts and results. The Parliament, which enacted the SURFACE Act in 2002, by a subsequent legislation, later law, leges posteriores, priores, contraria abrogant. A later law will provide if there is an inconsistency. Otherwise, both laws has to be construed harmoniously. They coexist. I'm not saying that SURFACI Act is not applicable. SURFACI Act is applicable. All enactments will apply. But this subject to this, they coexist. The recovery or action that SURFACI Act could have been initiated only on the permission or in the manner permitted by the committee. No committee was formed. No court asked, did you ever constitute a committee? I've been appearing ever so many matters. I've never seen any court ever asking any bank, did you ever constitute any committee? In case of any bank, it is scandalous. Courts has to be seen to be holding the scale even. Court's job is not, courts are not recovery tribunals. BRTs are recovery tribunals, we say in the open. But High Court cannot be a recovery tribunal. So courts, no court is asking. No court is asking, why did you consider committee? Therefore, my prayer is, the new repetition prayer. My prayer is, last one. I sought a cancellation of the license. Cancellation of the license of these bank and financial institutions. Under the Banking Regulation Act, action can be there. The board of directors who are responsible or liable to be removed. Something has to happen. Taking into the practical limitations, but something has to happen. It cannot be that they can violate the law with impunity. So that is the what of jurisdiction. Certiorari will lie where they say, as a matter of right. I'm the last man in all humility, but when I represent a litigant is not a beggar. We all, the courts, we lawyers and judges owe a duty to the litigant, to the public, these people of this country to do justice. We exist for them. We are not their masters. We exist for them. We for the litigant, the people. This institution should not fail. This institution should be open to all and should do justice. And where it is wrong, it should correct it. It cannot be that all these principles apply to Antulay. I have cited Antulay ever so many times. Antulay says, errare est humanum. And says, perseverare diabolicum. Persistent error is diabolic. And says, on the ex debito justitiae, out of obligation, ex debito justitiae. Actus curi neminem gravabit. Nobody shall suffer an injury because of a mistake of a court. And it is a duty of the court to correct itself. Ex debito justitiae. That is Antulay. Nowhere it is referred. Antulay is only for Antulay, not for MSME. So secondly, violation of the principles of natural justice. The magistrate passing an orders against a borrower without notice to him, without hearing him, that can never be accepted. If that has happened in this country, that's a failure of the bar. The failure of the bar to point out that courts cannot be allowed to commit such mistakes. And how this mistake came? Everything has been misunderstood. Because of misconception, the judges have failed to understand the basic jurisprudence and interpret it in accordance with the Constitution. When we say, we worship our judgments based on the strength of the bench. Strength of the bench is not a criteria. What is determinative is the principle, whether it is said by 2 judge, 4 judge, 5 judge, 9 judge, 11 judge, etc. But we worship. And Antulay says that in paragraph 44. Antulay's judgment in paragraph 44 say that now we worship a new system. That is, the strength of the validity of a precedent is determined by the strength of the bench. All right, I go by that. In paragraph 44, Antulay, my lords. My lords, in paragraph 44, I am here. Reading paragraph 44. The principle in England that size of the bench does not matter is clearly brought out in the decision of Lord Warshad Ammar in so and so versus so and so. The law laid on by this court is somewhat different. There is a hierarchy within the court itself here, where larger benches overrule smaller benches. So this is against jurisprudence. Now, but we follow the strength. Then the judgments of the 7-judge constitutional bench in Antulay, in Manoj Gandhi. What was involved? What the convention was? The Union of India said it is a issuance of a passport is a administrative function, and therefore the principles of natural justice is not required to be followed. But the court said the distinction between administrative and judicial function has come to an end, or obliterated. The word used is obliterated. It elaborately quarters. Its judgment running to 72 pages, something which should have been written in 7 pages. Extracts, elaborately extracts Ridge versus Baldwin by the House of Lords in 1940. And House of Lords in 1940 corrected a great error, which was a decision of the House of Lords in Nakuda Ali's case. Nakuda Ali's case coming from Sri Lanka. In Nakuda Ali's case, the House of Lords says, contrary to the then existing well-settled principle that if a function is administrative, then the principles of natural justice need not be observed. And in Ridge versus Baldwin, the House of Lords said it does not matter whether the function is administrative or judicial. If it cause adverse civil consequences, then the party has to be right to be heard. And that judgment, then with that judgment, we reverse the police Ashok Arora's case, police commissioner's case, and said for the first time by the 2-judge bench of the Supreme Court in the Beena Pani Devi's case. That was a case where a superannuation of a government employee in Odisha. Then the Supreme Court said no distinction can be made between the administrative and judicial function. If it indulges in the violation of, indulges in civil rights, infringement of civil rights, the parties has to be heard. And then came Kripak, again said the distinction between administrative and judicial function has obliterated, and the principles of natural justice has to be observed. Then came Manoj Gandhi, and then came MS Gill, then came Swadeshi Cotton Mills, and then another issue came. If a statute has received the protection of the Chapter 9 of the Constitution, Schedule 9 of the Constitution, whether fundamental rights can be infringed. In D. Colo's case, 9-judge Constitution bench, which was delivered on the 6th of January 2006, the 7-judge Constitution, not 9-judge, 7-judge Constitution bench said, 7 or 9, I have a little doubt. Yes, Constitution bench said, even a legislation which is, pardon me?
Yes, I have initiated, and on the date of possession, I have undertaken before this court that notice they have produced as exhibit 81. Page number 81.
No, my lord, battle lines be drawn. Yes. Okay. Adeda case है ना? Adeda. What serial number? Yes. Now, my lord, the practice of when a matter is before this, they come to take possession, that cannot be allowed. This borrower cannot be treated like this. The bar has been silent. I will not be silent. No, my lord, I am alone. Alone, I will fight. Alone. I am alone is enough. Then when I am here, they are come to take possession. Is it not contempt? No, sir, I am here before this court. I am before this court. How dare you take possession? Then we will break open it. Yeah, yeah. You can't do that. If you don't respect law, we also don't respect law. My lord, my IA is no.
In both cases, I filed the counter and documents. Seventh, yeah.
NBFCs cannot escape. You are under a statutory duty. Don't talk about public money. And we know what you did with many Ambani and many things.
Lordship 42521. Yes, it's a counter. Yeah. Counter 590. Seven and 8.
Whether NBFCs are covered. Yes. No, my lord, the other matter also is a
They have produced IA.
no, my lord, no, my lord, that's an order of the court. My, yes. No, my lord, yes. My lord, there are other IAs.
There is no order. I have taken an undertaking.
The two. Yes.
Additional notice, exhibit 74, 73, 74. The petition 4639, 4639.
The two. Yes.
Yes, 25 crores. The total amount is 25 crore. Outstanding, running page
Yes,
75.
yes. Oh, yeah. And who is appearing in this matter? Madam, you are appearing in this matter?
Yes. That is
425. Yes, yes.
No.
That is your, that's just
Outstanding also.
1 crore.
25, 6, 2025.
Huh?
6,
Okay,
2025.
okay.
25 crores maybe. രണ്ട് ലോൺ ഉണ്ട് മറ്റത് 101 crore and the other is 25 crores. Yes, minimum.
And my lord, one more matter. Can agro spices.
In this case,
No, my lord, it's a court's order. I'm not saying it.
this one today. Yesterday we have taken one position. Today we are going to take a position. We have visited the premises of 2 o'clock. On the basis of this case, the advocate commissioner is not taking position. The managers from Madras, from where they have approached this today morning, they came to the Kerala only for taking this position. But now the difficulty is that he can submit before the initial level. At the initial time, he can submit before the school. The notice is given in 1st December. And your lordship this court, may not pass any conditional order. But this case, because already they have in the morning and starting the argument, you can submit before the school. Yes. The 33 crores is the total. Below 33 crores.
In both cases. So I think our
This is Axis Bank. This is Canada Growth 33 crores is the outstanding. അല്ല ഇതില് ഒരു കേസിൽ രണ്ട് ബാങ്കിനും ടച്ച് ചെയ്യേണ്ടത് അല്ല 42585 അല്ല അവർക്ക് മാത്രം സ്റ്റേ ഉള്ളൂ സ്റ്റേ ഇല്ല. ഇപ്പൊ പൊസിഷൻ എടുക്കുന്നതിനാണ് ഇപ്പൊ അവര് ഈ ഫയൽ ചെയ്തേക്കുന്നത്. ഇപ്പൊ now benchmark.
See, when I am here, how can they take a possession? How can it be done? അതങ്ങനെ ചെയ്യാൻ പറ്റിയ? No, then my lord, tomorrow I will ask them to break open. I will say Matthew Dumbara said, do it. No, I will do it. Yeah, yes. Who will see if you pass an order? No, that is not proper. മര്യാദയാണ് ഞങ്ങളുടെ മര്യാദ. My lord, now what I am concerned today is this one IA number ഏതാ പറഞ്ഞു വേന്ന് പറ. IA 4 of 2000. If you go to Dadagiri, then we will also do that. Don't think that we can be frightened. No. IA number 4 of 2026. My lord, they have come to take possession today. In repetition number 46397. 46397. 46. Yes. IA number വേന്ന് പറ.
IA 234. IA 2345.
IA1 we have taken possession. അല്ല രണ്ട് IA ഒരെണ്ണം ഞങ്ങൾ പൊസിഷൻ എടുത്തു യെസ്റ്റർഡേ. അതും കൂടി പ്രൊഡ്യൂസ് ചെയ്തിട്ടുണ്ട്. തൃശ്ശൂരത്തെയാണ് ഇപ്പൊ എടുക്കുന്നത്. തൃശ്ശൂരത്തെ ദാറ്റ് ഈസ് IA നമ്പർ 2/20.
IA 4.
കുറെ IA ഒരുമിച്ചാണ് ഇപ്പൊ എഴുതിയത്. IA 4 ആണ്.
IA 4, my lord.
അത് എറണാകുളം CG ആണ്. ദാറ്റ് വാസ് ടേക്കൻ പൊസിഷൻ. സ്റ്റേ പെറ്റീഷൻ ഒന്നും ഇതിൽ കാണാൻ പറ്റും. IA 10 വെച്ച് 4 വെച്ചിട്ടുണ്ട് ഒരു IA-ല്. ഏതാ IA എന്ന് മനസ്സിലാവുന്നില്ല.
സർ കാനഗ്രോ അല്ല ഇപ്പൊ അവർ അണ്ടർടേക്ക് ചെയ്തു.
In Ernakulam property, we have taken possession.
Yeah.
That is IA number, that can be closed.
My lord, I would say an order can be passed. Whatever order your lord should pass, it may be IA number, or repetition number is enough, my lord.
അതുപോലെ IA പിന്നെ ഇതിന് കൊടുത്തേക്കും അത് കാണാം. IA ഇതിൽ എഴുതിയിരിക്കുന്നത് 32. IA 3 എന്ന് എഴുതിയേക്കുന്നത്. 3 എന്ന് എഴുതിയേക്കുന്നത്. Running page 32.
പറയൂ.
Sir,
Running page 32.
Your Lordship, IA 6 of 2026 in writ petition 46397 of 2025. Yes. Please to grant interim stay against the respondent bank on further measures under section 13.2, 13.4 and 14. But
Yes. 34 crores. You're not pleased to see that? I have taken possession yesterday, one property. Today, another property, Trishur, we are going to take possession. ഒരു കുറേ property ഉണ്ട്. ഇപ്പൊ തൃശ്ശൂർത്തെ മാത്രമാണ് ഇപ്പൊ ഇന്ന്
ഇപ്പൊ തൃശ്ശൂരല്ലേ വന്നേക്കുന്നത്? തൃശ്ശൂരാ വന്നിരിക്കുന്നത്. തൃശ്ശൂർ പ്രോപ്പർട്ടി യു ആർ ടേക്കിംഗ് തൃശ്ശൂർ. അത് കാനഗരോ അല്ലേ? യെസ് യെസ് 42585 റൈറ്റ്. 4
പ്ലീസ് ഈ അയ്യേടെ ഒരു ഡൗട്ട് ഇതിൽ കാണാൻ പറ്റുന്നില്ല. ഈ അയ്യേടെ കൺഫേം ചെയ്താൽ മതി.
ഒന്ന് പറയൂ, IA നമ്പർ പറയൂ. My lord, IA number 4, 5 and 6. 6 is IA number 6 is stay petition. Yes. 6 IA number 6. IA number yes.
It's mentioned that it's a Trishur property, Trishur CJ model. Otherwise, there is a confusion. തൃശ്ശൂർത്തെ ആണോ മഞ്ചേരി വേറെയാണ്. മഞ്ചേരി മലപ്പുറം അതല്ല തൃശ്ശൂർത്തെ
ഇത് പറഞ്ഞോളൂ.
no, two IAs, two properties as mentioned.
ഇതിൽ റണ്ണിംഗ് പേജ് 32 യു വാച്ച് മൈ ടേക്ക് റണ്ണിംഗ് പേജ് 32 അല്ല പേജ് നമ്പർ 22 പേജ് നമ്പർ 22 ഐഎ തന്നെ പേജ് നമ്പർ 22
IA number 6 stay petition.
IA number 6. IA number 6.
എനിക്ക് തന്നേക്കുന്ന അതെ അല്ല 1 2 3 ഉള്ളൂ. അത് 1 2 3 ഉണ്ട്.
Sir, IA യുടെ
22
sir, ഇതിന്റെ ലാസ്റ്റ് പേജ്.
Too many cooks in spoil the broth.
last page
Sir, IA 3 of 2026 in 4 to 5.
Yes. IA 3 ആണോ?
6
IA 6. IA 6.
ഇതാണ് sir. To grant under section.
Yes. Yes. Yes.
4 to 5.
42585 of 2025. IA 3.
തൃശ്ശൂർത്തെ അല്ലാന്ന് പറഞ്ഞാൽ കൺഫ്യൂഷൻ ആവും. Your Lordship has also record with regard to the Ernakulam position we have taken. Otherwise, it will be
No, sir.
again they will come with the
That is good. അത് കണ്ട് അവിടെ നിൽക്കുന്നുണ്ട്. 585.
Yes. Yes.
yes.
Yes. Yes. Yes. Yes. Yes. We have been banking for 30 years. കുരുമുള ചീത്തയായി പോയോണ്ട് പ്രശ്നം. 30 years.
That I will submit. That is report. Can agro മാത്രം. Can agro is against RBL. Correct amount വേണം.
ECGCയുടെ പൈസ തന്നാൽ മതി, എല്ലാം തീരും. ECGC പൈസ ക്രെഡിറ്റ് ചെയ്ത
എല്ലാം ഒരുമിച്ച് വന്നേക്കണം. There is a confusion. Your Lordship, എറണാകുളത്ത് പൊസിഷൻ എടുത്തു എന്നല്ലേ? അത് റെക്കോർഡ് ചെയ്യാനല്ലേ പിന്നെ
Lordship, that I am disputing it. What he said, I am disputing. But my lord, my
the amount is not paid, we can
your Lordship, may I add one sentence. One sentence, my lord. Your Lordship may record that I deny the liability. I'm under the one. No, your Lordship may record my, otherwise should not appear that I consented. But one word is that, my lord, I may dispute the liability.